Rural tax developments for the week of June the 25th, 2018. I'm Ed Zollers, broadcasting here from Phoenix, Arizona. And current federal tax developments, as always, is brought to you by Kaplan Professional Education and your state societies of CPAs. This week's kind of interesting because I had all of these cases lined up. I had things ready to go. I was coming back from the New York City area where I'd been doing courses for both the New York State Society of CPAs and the New Jersey Society of CPAs. And I was sitting on the plane getting ready to go, was on the Wi-Fi, and suddenly we changed this week's program. U.S. Supreme Court this week dropped their decision in the Wayfair case. And so despite the fact that if you take a look at our basically our updates for this week, you're going to find that I have, in addition to the Wayfair article on a couple of other updates. Those we'll probably discuss next week. And we're going to spend this week discussing Wayfair in its entirety because we have just upset 50 years of what's been essentially quasi-settled law in the area of how sales and use taxes apply in the United States. And now we're going to this brave new post-Quill world. Well, let's go ahead and get started with what we have this week. Let's talk about the case. In case you were under a rock somewhere, you might not have heard, but the United States Supreme Court on the 21st of June issued its opinion in the case of South Dakota versus Wayfair. For those who do not remember, the question involved in this case is under what circumstances may a state force a seller who is selling products into that state, products or services actually into that state, to collect the state's sales and use tax. This particular case this week came down with a 5-4 decision. 5 justices in favor, 4 opposed, in favor of South Dakota. And therefore, South Dakota, that means flipping that slightly. That is 5 justices in favor of getting rid of the Quill decision and getting rid of the physical presence test. Previously, in order for a state to be able to assert that a company had to collect sales or use tax, they had to, under the Quill standard, come up with at least some theory about why the company had a physical presence in the state. That theory about how the presence existed sometimes became rather strange. For instance, we've had the discussion earlier, in fact, last year, about the cookie nexus, which Massachusetts adopted, and then Ohio came along and decided that'd be a good idea too. You know, where we said the physical presence for the seller was that they stored a cookie on the buyer's machine in our state, and that gave us the physical presence to tax. But up until this case, we had to find some physical presence in order for the state to be able to tax it. We gave discussions about doing things that we call economic nexus, but the reality was that with Quill sitting there, pure economic nexus couldn't work. Now, maybe it does. One thing, though, to remember is, and this is something I've heard lots of people get lost on in this case, physical presence was required for nexus, but physical presence was not by itself everything that consists of nexus. Merely the fact that we no longer have to have physical presence to have nexus does not mean that we have nexus if we make a single sale into a state. Rather, we start to get to a different set of tests to discover whether there is a sufficient connection to the state to allow the state to tax the sale. But that's a whole different issue. And in reality, what they have now done is basically put us all on a very similar set of rules, shall we say, for purposes of what is nexus for various types of taxes, rather than having this different rule for sales and use tax. In essence, we're now going to what the court refers to as the complete auto test. Complete auto was a case decided between National Bella Hess and Quill, and which Quill kind of worked around. And now the court has said, well, we're not going to do that anymore. We're not going to be following complete auto when we're going to be testing sales and use taxes. So we'll take a look at some of this issue. Let's talk about the history that's behind this case. As I said, there is 50 years of law, Supreme Court law, related to the requirement that there be a physical presence. The physical presence test was first enumerated in the National Bella Hess case. 1967 case, the state of Illinois tried to tax a catalog retailer, National Bella Hess. The Supreme Court ruled in that case that in the absence of a physical presence in the state of Illinois, the state of Illinois could not tax National Bella Hess just because they were selling products by mail order to individuals who lived in the state of Illinois. The court held in that case that to do so would violate both the due process clause of the Constitution, or at least implied it would, and also ran afoul of the Commerce Clause. Now, we went along with that for a while, but about 25 years later, we had, the economy had developed, things had changed a bit. In 1992, we still had mail order, and mail order was still significant. But obviously, things had grown. The catalog for the amount of remote sellers had changed, and we had major nationwide remote sellers selling big products. One of the big ones at that point was sending catalogs everywhere, and those of us in business remember this. And by the way, they're still around. You can still buy from them. But we used to get these physical catalogs from the office supply seller Quill. And in 1992, the state of North Dakota challenged Quill. And again, like Illinois and National Bella Hess, the state of South Dakota said, well, Quill, you're selling to people here in North Dakota. Now, they did play lip service to trying to figure out what physically was in North Dakota that could allow them to come after it. And the state of North Dakota argued, well, this is the beginning to a certain extent of the argument for economic nexus, where they said, obviously, you're targeting our markets and you're going after our residents and you're benefiting from the fact that we have roads and other things you can deliver on. But ultimately, one of the more interesting things they claimed that allowed them to tax this was that Quill sent a bunch of catalogs into the state. Those catalogs were physical catalogs, which most people threw away because you realize if you're in the mail order business, you're going to send out a lot of catalogs knowing that a lot of them will be trashed. And even the ones that weren't trashed immediately, obviously, they eventually become not up to date, so we trash the catalog. So those catalogs had to be disposed of in landfills that were run by various local governments in North Dakota. So North Dakota claimed we have a right to tax that. The Supreme Court took the case up in 1992. In the interim, between 1967 and 1992, the court in 1977 had taken up a case called Complete Auto Transit. This particular case, US 274, which is US Supreme Court 450, I should say, let me get this right, 430 US 274. That's your citation on it. In that case, basically, the court in that case held that a tax would be sustained so long as it applied to an activity with substantial nexus within the taxing state, is fairly apportioned, does not discriminate against interstate commerce, and is fairly related to services the state provides. That was the complete auto test, and that was a general test for a fair tax. Now, North Dakota was hoping, since that had occurred after National Bella Hess, actually 10 years after National Bella Hess, and since they had had these changes in the economy, that, the court would now allow them. The court, however, stepped in and decided that, well, okay, we know we have this National Bella Hess case, and we know that physical presence rule was never really referenced in complete auto. But the court held a couple of things. One thing the court held was they did get rid of any theory that a state taxing a seller located in a state imposing the requirement to collect a tax on a seller that is operating in another state but is selling into their state does not violate the due process clause. In the Quill case, they came to the decision that obviously, you have the same rights, you have obligations. It's not violating due process. The world, it communicates now. It's not that difficult for the communications to go. You can pick up the phone line. You can deal with that. So they felt that there was no longer any due process issue that would prevent the state of North Dakota from requiring Quill to collect the tax. However, they did continue to decide that they would uphold National Bella Hess They felt that they were going to still continue the requirement that in order to meet the first prong of the complete auto transit test, that is, to show that you have substantial nexus with the taxing state, that a absolute requirement for sales tax only, the absolute requirement was that you have to have physical presence. The court mainly justified this by using the concept of stare decisis. That is, that we don't overturn prior precedents lightly. And even though a number of justices were somewhat uncomfortable with the fact that National Bella Hess didn't really integrate well with how they had reasoned in complete auto transit, they decided that because companies had relied upon National Bella Hess and this absolute bar provided by the physical presence test, that they would continue that. Now, this decision under the Commerce Clause is of a type of court case that's called a dormant Commerce Clause case. What dormant Commerce Clause means is the Commerce Clause itself provides that Congress has the right to regulate interstate commerce. But the Supreme Court had decided, we go way back here to actually John Marshall as Chief Justice, the first U.S. Chief Justice, and a pair of cases decided under his watch. And ultimately, it was decided that Congress has the right to regulate interstate commerce. However, if Congress has not yet spoken on a matter, the states have some rights to do things there that could impinge on interstate commerce. However, the courts have provided understanding the goal there. If you remember, one of the big problems with the Articles of Confederation were that the individual states effectively were putting up their own tariffs and blocking sales between states so that the United States couldn't really operate as a single economy because everybody protected their own little area. So the Constitution was meant to try to stop that. That's why Congress had the right to regulate interstate commerce. The Supreme Court under Marshall, understanding that, had come up with this concept that there would be this general broad set of rules that would be applied called the Dormant Commerce Clause rules that basically sought to keep the states from interfering too heavily with interstate commerce, even if Congress had not acted. But the key takeaway from that is Congress always has the right to step in a dormant Commerce Clause situation and actually go ahead and go from dormant to active. And Congress can then outline the rules and step in. The court doctrine is merely a kind of a placeholder that stays there until Congress takes up the issue. The majority in Quill invited Congress to solve this problem for collection because they noted that, economy's changing. This is a lot bigger deal than it used to be. And Congress, this is something that we think you're perfectly suited to take on. Unfortunately, since 1992, Congress has done absolutely nothing with regard to this. Congress did not take up that challenge. For Congress, probably this looked like a lose-lose proposition. That is, if they did anything to expand collection of sales and use taxes, it would look like a tax increase. And the flip side of that is it's a tax increase for which Congress doesn't get to actually spend the resulting money. So, you get nailed at the ballot box for having increased taxes, but you didn't get to give anybody some benefit, from some program by spending the money. Therefore, not surprisingly, Congress did not act. That led us to the current case. This case was set up by Direct Marketing Association versus Broll. What happened in that case, and we discussed that case when Colorado brought it up, but what happened there was it went to the Supreme Court once on a jurisdictional issue. There, Justice Kennedy, who, by the way, was one of the justices that voted to uphold the physical presence test in Quill. Justice Kennedy did that. Another justice that is on the current court also voted to uphold, Justice Clarence Thomas. We'll get back to those two here shortly. But Justice Kennedy, in a concurrence saying that effectively the federal courts had a right to rule on the DMA versus Broll case, noted that he felt that Quill was outdated, that it probably needed to be essentially thrown out, but that this wasn't the case to do it. Effectively, we all determined very quickly that Justice Kennedy was probably going to be a vote to overturn Quill. Then, when it went back to the federal courts and eventually came up before the 10th Circuit, one of the judges at that time on the panel that was appointed to hear the appeal of DMA versus Brohl was a Judge Neil Gorsuch. That Judge Neil Gorsuch, in his concurrence, also clearly indicated that he felt that Quill was outdated and probably need to be junked, but it didn't matter in the GMA case because they weren't violating Quill. They weren't asking to collect tax. So what happened was it became very clear once Justice Gorsuch was confirmed to the court that it looks like we had 2 votes, clear votes, to overturn Quill. We had a court that even back in the Quill decision didn't appear totally comfortable with the concept, and maybe now was a good time to bring something to court. The state of South Dakota took up the challenge. The state of South Dakota passed a law that absolutely makes it clear if you have no physical contact with the state of South Dakota in any way, shape, or form. But if you have sold to South Dakota residents more than $100,000 of product or services, or you have more than 200 transactions with customers in South Dakota, you are required to collect and remit the South Dakota sales tax. There is no requirement that you have any physical presence in the state of South Dakota. This is the first pure economic nexus statute. There's not a pretense that there's any physical presence. We are not arguing cookie nexus. We're not arguing any sort of issue except for the pure economic connection with the state that you sold funds into the state. This is a pure economic nexus case, 100%. South Dakota obviously was challenged on this. South Dakota went against 3 companies, Wayfair, Overstock.com, and Newegg. These are 3 major internet sellers who, by the way, did not collect sales tax in the state of South Dakota. They went after them for the taxes they weren't collecting. The companies, of course, filed suit claiming this violated Quill. They won in South Dakota State Court. The South Dakota legislature had provided that as soon as that happened, they could appeal to the South Dakota Supreme Court. The case went to the South Dakota Supreme Court, who also upheld and found for the sellers, noting that Quill was the law of the land and the South Dakota Supreme Court had no authority to overturn Quill. But that set up, therefore, the right of the state of South Dakota to appeal this case to the place that could overturn it, the United States Supreme Court. That's what got us to the South Dakota versus Wayfair case and the court's decision. In the opinion issued this week, all 9 justices agree Quill is bad law. Quill is badly decided. If they were deciding the National Bella Hess case today, they would not follow the physical presence standard. So all 9 justices agree that it does not fit, it doesn't integrate with the complete auto test, and that basically, if we were starting from scratch, we wouldn't do it. The majority felt that this is so far out of link with complete auto, and it is also the economy has changed in such a dramatic fashion to eliminate a lot of the problems that they were concerned with National Bella Hess, when compliance in the view of the court would have been much tougher for remote sellers. And the remote sales have become such a large enterprise, and specifically, of course, the size of enterprises like Amazon became huge. We should say, even though Amazon actually collects sales taxes in all 45 jurisdictions, they don't necessarily collect those sales taxes for those who sell through the marketplace. And actually, over half of sales that are made on the Amazon website are made via marketplace sellers. That is, when the actual seller is not Amazon, but the seller is some other company. And if you've shopped on Amazon, you should notice that, right? You have the option of multiple places to buy something from. Amazon will give you the low-cost option, even if that option happens to be something that Amazon itself would sell you. So this is based on all these changes. The majority felt this law is out of line. Yes, we understand the concept of stare decisis and not changing precedent lightly, but it was felt this precedent should be changed. Completely to the point is interesting, of the 5 judges who voted for this, 2 of them, Kennedy and Justice Clarence Thomas had both voted on the basis of stare decisis to keep the physical presence test in the Quill days. In fact, Justice Thomas, in his concurrence, basically states at this point that he was mistaken back when Quill was decided to decide that keeping the precedent in line was more important than rightly deciding the case. Now, he was an interesting vote because most everybody knew two things about Justice Thomas. He has reputation in a couple of areas. Number one, Justice Thomas does not like overturning precedent. So he has a high level of respect for keeping precedents in line. But number two, Justice Thomas hates dormant Commerce Clause decisions. So this case kind of was the perfect, which one of the two did he hate the most? Overturning precedent or going ahead and going along with the Dormant Commerce Clause, where frankly, probably the way he would probably phrase it, his view is Dormant Commerce Clause comes awfully close to the courts assuming a legislative function to put rules in. Congress hasn't, so we'll put some down here for you. So that gets kind of interesting. We had the 5-4. It was kind of an interesting case when it came down with that. It's also, by the way, as I remarked online one time, this is one of the few cases I can remember where in a 5-4 majority, Justice Ginsburg and Justice Thomas in a 5-4 split were on the same side. They both came out and did it. Now, there were 4 justices in the minority. Those justices were Justice Roberts, Chief Justice Roberts, who wrote the dissent, Justices Breyer, Keegan, and Sotomayor. Those justices argued that due to the fact that companies have been relying on the physical presence test for ages, that in reality the court should not disrupt it and continue to leave the issue for Congress. If you listen to the actual oral arguments, you will discover that almost as soon as South Dakota's Attorney General began speaking, Justice Sotomayor jumped in with a serious concern about how this could basically be a mess for companies to comply with, especially small companies to comply with, and how, despite the theory that this could all be solved with software, she didn't buy that. And it became very clear. I was certainly not surprised that Justice Sotomayor was a no vote in this decision, that she was going for, Wayfair should have won. Justice Breyer also was pretty clear that he didn't think we should be hearing the case. He, kind of gave that opinion. Justice Kagan wasn't quite as obvious, but she seemed to indicate and lean toward, again, this view. And Justice Roberts also seemed skeptical about stepping in and doing this. Those 4 argued that, and I think to a large extent we can say they were a combination of both. We don't know what mess we're going to unleash if we turn this loose, and also that this is really the court legislating. We probably should, Congress has the clear ability to deal with this. The fact they haven't done so far, that's not really our problem. So we'll leave it that way. But in any event, we're now with the majority. So now the question becomes, where do we stand? Well, interesting thing. We have now already seen North Dakota issue announcements on this case. Let's talk about what the real decision was. The court decided clearly that we don't need physical presence. However, that does not mean they decided the South Dakota law was valid. What the court decided was that physical presence isn't necessary. But the court also notes that, other things can get in the way of allowing a state to do the tax. For instance, the tax might still be discriminatory against out-of-state businesses. It could even arguably be discriminatory or interfere with interstate commerce because it's too complicated. Right? It's going to be difficult to apply this law for out-of-state. For instance, here in Arizona, we allow cities to have a certain level of what will be called home rule in terms of deciding their own sales tax rules. So not only if you're selling into, let's say here, to me sitting in Phoenix, not only do I need to be able to work around the Arizona rules, the Arizona state level rules, but I also have to know what the city of Phoenix rules are. And there's also a Maricopa County tax on top of it. It applies to certain things. So I have to be able to navigate the state of Arizona's not terribly simple rules on what's taxable at what rate. Then I also have to apply the differences that may exist as to what the city of Phoenix will subject to tax, and potentially how the Maricopa County tax that goes on top of this thing, which is really run by the state, but what that special case applies to. And I have to multiply that by all the other 44 states that I may need to comply with to get this done. So the court found that yes, it could be too complicated. It could be that since they have, they only sold they sold a $5 item into the state of Arizona, that they shouldn't need to comply with Arizona's detailed requirements. So it was sent back for trial. However, the court made it very clear, and in this particular case, that even though they're sending it back to South Dakota courts to see if there's some block here, they clearly, Justice Kennedy and the majority, Justice Kennedy wrote for the majority, apparently like South Dakota's law. As they said, quoting from the opinion, that said, South Dakota's tax system includes several features that appear designed to prevent discrimination against or undue burdens upon interstate commerce. First, the act applies a safe harbor to those who transact only limited business in South Dakota. As I noted, if you sell less than $100,000 worth of products in South Dakota and have fewer than 200 transactions, you don't need to collect South Dakota sales tax. So if I ship one coffee mug to one person in Rapid City, and I charge them, I probably not a $100,000 coffee mug, so let's say I charge them $12 for the coffee mug, I don't need to comply with South Dakota's sales tax. Second, South Dakota ensures there's no obligation to remit the sales tax retroactively. South Dakota in their law said, we're not going to go back and say that you should have been collecting this 15, 20 years ago, and we want 15 or 20 years of sales tax. Third, South Dakota is one of the states that has adopted the streamlined sales and use tax agreement. This is interesting because that was what the states had been trying to put together in order to enable, in order to get Congress to allow them to charge sales taxes to simplify matters. The Streamlined Sales and Use Tax Agreement provides for a simplified application of sales tax where you don't have to go digging through something like Arizona's localities rules, but you can apply a rather standard rate to a state. For instance, Alabama has a simplified rule with them where you can just collect 8%. We don't worry about what you should have collected for what you should have sold, the product you sold, who you sold it to, where it was sold to in Alabama. You can just do a simplified entry 8%. Streamlined sales tax looks to provide those types of options to those selling outside the state. South Dakota is a member of that. By the way, the largest states are not members of that. So states like California and Texas, are not members of the Streamlined Sales and Use Tax group, although 20 states, in this case, I believe it is 24 states, I believe are, but some major states like New York, California, Florida, Texas, we're missing some big ones here. Oh, by the way, my home state of Arizona is also on the missing list in that group. And finally, the state of South Dakota has a system that allows you to essentially access the sales tax administration software that's paid for by the state of South Dakota. And if you use that software to deal with your sales tax issues, then you're not going to have risk of audit. The key question becomes, what about state laws that don't have all those issues? Well, North Dakota tried to adopt a law that, at least in terms of sales numbers, $100,000, 200 transactions are the same as South Dakota. And on the day the decision came down, the South Dakota tax commissioner posted on the website. In fact, I loved it too. It was in red banner on the North Dakota tax website, that they were essentially now rolling out to get ready to actually enforce this law. They have information about signing up. They had everything ready to go on the day. Obviously, they were ready for it. Other states have also begun announcing that they're looking at things. Some are, like Louisiana's indicated, that while they have the statutes in place, they're going to be taking their time. Other states are moving like North Dakota. We're going full speed ahead. Okay, that's the key issue in this regard. Now, some of the other things that we ended up with. So North Dakota is going in place. Other states have gone in motion already, we've noted. One thing I think we're going to run into that is serious here. So let's talk about this for a second. What does this do for your clients, and what should the clients do? First, there are, from companies like Aloe Vera, products available that can allow you to, Aloe Vera will take care of filing sales tax reports for you. They will also, supposedly take care of finding rates for you. And it's great. And you buy it, it works. That's wonderful. Except as anybody who's used will tell you, there's one problem. It's got to be integrated into your sales system. And you've got to handle in your inventory the mapping of what you are selling to all of the categories that fit for all the states, and potentially, like in Arizona, the localities that you may need to collect tax for. And that, as anyone who's done it will tell you, is a long, tedious, messy process that somebody's going to spend a lot of time working on and a lot of time keeping up with. So the problem is the solution may be much more costly than it first appears. I know the justices thought that we could solve this with sales, with software, but it was Justice Sotomayor was pointing out during questioning that, yeah, there's all these other issues besides just the base cost of the software. And the base cost may not be much, but getting all these other things together, that's a mess. And yes, I agree with the justice. That's a mess to deal with that. So we have that particular issue. Now, the due diligence problem I'm going to mention is, here's a problem we're going to have. If you have a client that now someone's looking at acquiring, a public company is looking at acquiring your client, expect that due diligence teams now, especially following this case, they were already gun shy on sales tax nexus, expect them to be even more so. The problem your client needs to understand is, if they decide they're not going to collect the tax, if they decide they're going to move forward, they're going to try to be aggressive. If somebody comes to buy the company, don't be surprised if, as a condition of the sale going through, your client will need to pay for the basically for somebody involved with the due diligence or some other party to go after a voluntary disclosure settlement with all states that your due diligence team has discovered you've sold into in enough that it makes them nervous. And right now they'll be made nervous at a much lower level. That sort of due diligence issue is an exposure. And sometimes it's one that, when we're just working with clients day to day, the client thinks it's no big deal. But unfortunately, if a buyer shows up, that's going to get really expensive, because they're going to have to pay not only for the legal time involved in doing the application to try to get a settlement, but they're also going to have to almost certainly come up with and pay the taxes, penalties, and interest in question, because the buyer's not going to take that on. So this can get expensive fast. As I say, what clients should do right now, here's what I'm suggesting. Tell your clients who sell products into multiple states that they don't collect sales tax in. They need to look at the states they're not collecting in and figure out how much they are selling in terms of dollar volume per year and how many transactions per year they're entering into. It appears fairly obvious that, according to Justice Kennedy's opinion, that $100,000 of sales or 200 transactions would be sufficient to allow the state to tax them. So certainly any state where they clear the 100,000 or 200 transaction, they may very well not need to collect right now, because the states will need to adapt to this and get their laws in line. But they need to get ready for the fact. They also need to start monitoring states. I reasonably would expect states to test the lower end of this. So don't be surprised if you see states go down to maybe even $10,000 worth of sales, to try to argue that at that level, a company should be able to comply, especially with the majority opinion kind of suggesting, oh, the software will solve this over time. You need to keep an eye on them. They need to watch the states they're selling into. And frankly, they also need to consider if we decide we're going to try to sell into another state, can we make enough off the sales to justify the potential cost of having to comply with their sales and use tax law And oh, by the way, once you're on the radar for sales and use tax, don't be surprised if they start looking at, well, maybe you should be filing an income tax return, or maybe you should be filing a gross receipts return. Maybe you should be doing certain other filing responsibilities in the state. And because Complete Auto is now considered to be the test for taxes across the board, I don't be surprised if you discover that they have determined that if you have enough connection for sales tax under Complete Auto, you might have enough connection for, let's say, income taxes or gross receipts taxes. Yes, we do have the protection for the outside salesperson only in income taxes, which, by the way, does not extend to sales taxes. But otherwise, don't be surprised if we start bringing in these concepts so that the same test being applied for all is going to become more and more the norm, rather than having distinct siloed types of tests for each type of tax. Well, as I said, this has been the week of Quill. We're going to talk about the other issues that happened. There were a couple of cases. They're written up in the PDF materials on the website. We had one where the IRS published a list of designated qualified opportunity zones, and we'll talk a little bit about what those things are and how they work. And also, there was a case where a taxpayer attempted to get out of a fraud penalty by filing an amended return, and we'll also talk about how that failed. But those are both written up. If you want to read about them, you can. I probably will bring them back up next week. Otherwise, check your state CPA societies. We're reacting. And by the way, things like this, as I said, are the reason why it's really great to be able to go into a live course. We've got a live person that's able to talk about what's happened now, as opposed to getting a taped webinar, a taped broadcast or a taped program that you're going to do a test on that was recorded 6 months ago, and that obviously the person at the time didn't seen the Wayfair decision. So lots of useful things there. Your state CPA societies, they have courses. Take a look there at your state courses. Do we have a course coming up on state and local tax issues? Because that's where these are going to be discussed. Also expect our tax updates this year are all going to talk about the impact of Wayfair. For those of you in Arizona, who can get to Phoenix, can get to the Arizona Society offices of 4801 East Washington on July 2nd, or who can tune in on a webcast. It'll go from 8 to 11:30 a.m. that day, Mountain Standard Time. And by the way, it's Mountain Standard Time because we don't move our clocks here, Pacific. We are going to have a 4-hour course dealing with Wayfair, what its impact is, how we advise clients, and we're talking about the impact in lots of areas, not just the question of, what should we do for filing, because that's going to be coming up. We're going to talk about how we've got to watch and keep up with these developments as the states react to Wayfair. Also talk about, to some extent, how this impacts things like financial statements we're preparing, because that's an issue. We now have what has changed radically our view of potential contingent liabilities for tax collection that we haven't done in states outside of our home state. Do we now have issues there on the A&A side? And it's a live session. We can discuss the major changes. Obviously, live, best way live is always if you're in the room, because we can discuss right there. But even if you're online, you can forward in your questions and we'll try to deal with them there. And again, that's coming up July 2nd. I apologize for the date, but that was the one date that there was space available at their location to do this broadcast. And I actually had time free in the month. I wasn't scheduled to do something else. So it's July 2nd, bad timing, but hey, you could be on the beach, right? Be on the beach, and I'm sure your family won't mind if you're tuned into a webcast during that time frame. So if you're able to make it, take a look there. Arizona Society CPAs, you can find information on their website, ascpa.com. This has been the current federal tax developments for this week. And actually, it's been current constitutional developments, I guess is the way you look at it this week. You can follow our updates at currentfederaltaxdevelopments.com. We'll post their developments as they go during the week. And since Wayfair has been done now, I don't think, well, I shouldn't say nothing earth-shattering happens. For all we know, this week, they'll drop the first 199 Cap A regs. If they do, we'll probably be talking about those. But we'll take a look, see how things go. We'll post those updates online at the website. You can send any questions or comments to me, Ed Zollers at currentfederaltaxdevelopments.com. I post on Twitter So on Twitter, you can find me. My Twitter address is @EdZollers if you want to follow me there. And I also tend to follow discussions online on the subreddit at reddit.com/r/taxpros and at the California Society's Tax Talks discussion group, which you can find via Yahoo Groups. And as long as you're a licensed CPA in any state, you should be allowed to go in there. So I follow along there. And for those of you here in Arizona, I do follow along the Arizona Society's website. Well, it's certainly been an exciting year so far. We have a brand new tax law, and the Supreme Court now has upset 50 years of state and local tax law. Don't you just love living in interesting times? Well, we'll see next week how much more interesting they get, and I hope you're going to join us next week for our broadcast of current federal tax developments.